the Coye family had made an application to the Supreme Court to discharge an order made in 2010 that all funds, their personal bank accounts, their credit union accounts, every account involving the Coye family and a business that they were operating at the time, all those monies in those accounts were frozen in 2010 by virtue of the fact that a criminal allegation was made against the family and the business. And finally, that matter came to an end on the 4th of March this year in the Court of Appeal. And they were exonerated from the allegations that they had been guilty of money laundering. So what they did was made an application to the court that the court, not the criminal courts, but the Supreme Court, had made an order to freeze their funds. And yesterday, Justice Griffith heard arguments from other parties. The Financial Intelligence Unit had said that they were no longer objecting to the funds being unfrozen. And other parties appeared, the government lawyers appeared from the Solicitor General office to ask that the funds remain frozen because income tax would have wanted to see if they could charge more monies. That argument did not stand with the judge, and her ladyship said that in fact they had sufficient time, they had made an assessment, and the FIU had given a written affidavit by Eric Yusey, the new director of the Financial Intelligence Unit, to say that funds that he was holding were paid over to the Income Tax Department on Friday, the 2nd of May of this year. Those monies were paid in many years ago by another company who was also charged for money laundering. Those charges were withdrawn from that company. And they were saying, oh, that money belonged to the Coyes. That is a separate argument.